All right. Welcome, everyone. We're going to go ahead and get started. I want to welcome you and thank you for attending our Social Security workshop. My name is India Jones, and I am the Community Services Manager over here at Services for Independent Living. Let's see. I'm going to go ahead and show my screen. All right. All right, so just want to talk about some sponsors for today's workshop. Of course, Services for Independent Living. We want to thank Liner Legal LLC, and a special thanks to Jennifer Morgan for being a great addition today. Can't wait to hear what they have in store for us. Some of the housekeeping. Participants will be muted. If you have questions, please share them in the chat box. We will attempt to answer them at the end. If you have not already contacted me about receiving CEU credit for attending today, please comment your name and license number if you haven't already in the chat box. You will then be emailed a feedback form. Once that is received, you will receive your certificate. And then there will be a recording of this workshop available on our website at www.co-ohio.org. All right, so now I'm going to go ahead and put the mic over to Michael Liner and Jennifer Morgan. Thank you so much for being here today.
Thank you so much, and we're so excited to get a chance to connect with everybody in our audience. This is so much different than in the past when I've had an opportunity to present with my great friends at Services for Independent Living. It's my first time bringing Jen to present with me here. But you know, in the past, I've always been able to connect in person with the audience in the great conference facilities that you guys have in your office in Euclid. But so even though I can't see you, I'm still so touched that you guys you know, have taken the time to log on and participate virtually in a seminar, and I'm hoping that I can give you guys some great information. We're going to kind of today give a bit of an overview about Social Security. We'll give you a roadmap about our presentation in a minute, but you know, one thing that I always like to say is I know that, you know, the people in the audience, you probably have a diversity of experiences in terms of where you come to your knowledge of Social Security disability with. And so I'm going to try to speak from a, you know, at the lowest level possible, which I know may be frustrating for those of you who have more experience, but I'm also going to, you know, we're going to make ourselves available to answer questions for anybody who has questions, so that we can, if you have more advanced issues, I want to make sure that we can address those. Jen and I are both available. So if we can move on to the next slide, we're just going to tell you a little bit about ourselves. I'll start by telling you about myself since, okay, good, Jen. I thought I lost her for a second. Can we move on to the next slide? Perfect. So my name is Michael Liner. I am an attorney. I have a practice that is focused entirely on Social Security disability. We are based in Cleveland, although we have now 6 offices in Ohio. And I started my firm Liner Legal in 2013. I come to this practice you know, with a unique vantage point, specifically because I myself live with, you know, several different, you know, disabilities. I, you know, went to a special school as a, you know, growing up for children who have ADHD, and, you know, as an adult have motor tic syndrome, cluster headaches. I had epilepsy as a child. So, you know, I know what it's like to be labeled as different, to go through a lot of the things that my clients go through. Thankfully, I'm still able to work, but especially when I'm connecting with the parents of many of my, child clients, that's where I feel like I'm able to connect and really make an impact. And then, beyond my professional accomplishments, you see the personal accomplishments at the bottom there that I'm most proud of are my two kids, my daughter Eliana and my son Dylan. And then I'm going to let Jen, if she's been having some technical problems. So did she fall off of this? Well, I will introduce Jen because I think that she might have fallen off here.
Yeah, I think she
Jen,
fell off for a second, so you can go ahead and
she fell off,
introduce
but I
her.
think that she's almost back here. I
All
see
right.
that she did just sign back on with us. So
Yes, you guys hear?
yeah, we can hear you, Jen, and we can't see you yet, but I'm sure that can you just activate the video, then we should be able, now we can see you too. Why don't you?
Yay, okay, my apologies. Bear with me as I get this figured out. I think my internet is slow, but we'll figure it out. I did get to hear your introduction, Michael, so I was just on
Perfect.
audio. It's working a little bit faster, so you want me to go into my introduction?
Yeah, why don't you tell us who you are?
Okay, perfect. Thank you so much. So I, as the slide says, I started as a kindergarten teacher and then went to law school. Since that time, I've been working in education and disability law and founded Impact Disability based in Denver, Colorado. I think a unique thing about my practice is that I really do enjoy taking kids' cases, and part of our presentation today is sharing a little bit about those cases and how you can help your clients with the information that's needed to be successful in a claim. My son Hudson is that cutie in the black and white right there. He is actually almost 9. He will be 9 next month. So he is 8 and I don't know. I think he's saying 8 and 11 months or something at this point, but we're still in virtual school, so navigating that has been an interesting thing, as I'm sure many of you guys know. But we are based in Denver and just found out we get to go back to in-person school on his birthday, actually, so very excited about that. So yeah, that's a little bit about me. I'm excited to be here today. Thank you guys for having us.
Thank you. And we can move to the next slide. So this is just kind of an overview about what we're going to talk about today, just so you guys know where we're going to head. So by the end of the webinar, we hope that the things that you take away from this, we're going to talk about, what is Social Security disability? What is the definition? And we're going to try and break that down into the different parts of that, of the definition of what does it mean to be disabled under Social Security, the Social Security Administration's own definition of disability. We're going to talk about the two main programs that Social Security offers, one SSD and the other one SSI for adults. Jen is going to, because she's the expert on child SSI cases that she talked about, it is a totally different standard because, of course, the question for children is not whether they're able to work. And then Jen and I are going to talk a bit about, some keys to a successful disability claim. I think that's going to be a real big takeaway for the people watching, things that you can pass on to your clients, your patients, your consumers, the people that you're working with, if they ask you for tips on how to help them with their own case. And then, because we get asked these questions a lot, what are things to know about hiring an attorney? And is that the right move for them? So we can move on to the next slide.
Michael, before we do, and I know that you had mentioned this in the beginning, but we really try to meet people where they're at during the presentation. And so we'll be monitoring the chat. If you guys have specific questions, that's really what we like to address, because these are all very a general overview, which is amazing. But if there are specific questions that we can of work through. Obviously not like personal information, but just more specific things about the process. That's what the chat box. You can email us or call us after as well, but we really want to make sure that you're getting the information that you need and want. So,
is it possible to put this into actually just so yeah, into the presentation mode? Yeah, perfect. Thank you. Great. Perfect. That makes it a little bit easier for everybody to read the slides. So this is the technical definition of what Social Security is. Jen and I actually modified this a little bit from the statutory definition just to make it a little bit easier to digest, because the way that Congress defined disability is in a way that you would have to read 12 times to get through. We wanted this to be as easy to understand as possible. But Social Security disability is a government benefit for individuals who are unable to engage in any substantial gainful activity. We're going to come back to that. By reason of any medically determinable physical or mental impairment. So that's the second thing I want you to remember, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So there's 3 prongs to this definition here, okay? The first thing is individuals who are unable to engage in any substantial gainful activity, SGA. What does that mean? The first part of this definition, SGA, and inability to engage in it, in order to be disabled, somebody has to be unable to work and earn more than 12, this year the number changes every year, work and earn more than $1,260 in a month, okay? That's SGA. So, that's the first part of the definition, right? The second piece is by reason of any medically determinable physical or mental impairment. People ask us all of the time, can I get disability because I have, herniated disc in my back? Can I get disability because I am diagnosed with bipolar disorder, or because I have a cancer, a form of cancer? It can be because of any type of medically determinable physical or mental impairment. Now, I want to talk about when something is not countable. Sometimes people say, I have very severe pain, but the doctors don't know what's causing it. That's a symptom. That is not a medically determinable physical impairment. You have to have a medical diagnosis, diagnosed by an acceptable medical source, in order for it to meet that second prong of the definition. Okay, so that's very important. But it can be any medically determinable physical or mental impairment that can qualify to be a part of the definition of disability. And then the third piece here is what we call the durational requirement, which can be expected to result in death. So if somebody has a diagnosis that is terminal, that can qualify for disability, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So let me give you an example. Very often we will have people come to us and let's say that they had I just gave the example of cancer, and maybe they were diagnosed with a form, let's say breast cancer, something that's we all empathize with. It's something that needs to be treated. There's no question that for at least some period of time, the patient's going to be out of work, or the individual is going to be unable to work because they're going through chemo, maybe radiation in some circumstances. The treatment really depends on the specifics of that particular individual. But here's the thing. In many cases, from the time of a diagnosis until somebody can be considered in remission and fully recovered, it may not be 12 months. Because of that, we very often see that, breast cancer and other impairments like a car accident where somebody, shatters a leg, and the leg might heal in 9 months. That wouldn't qualify, it wouldn't meet the durational requirement if the person regained their ability to function in less than 12 months. So the durational requirement must be met in order for the person to be eligible to receive disability benefits. That's very important, okay? So that is the statutory definition of disability under the adult standard, okay? So that's one thing that is important for everybody to understand. If you have any questions about that, if you want us to dig any deeper, again, I invite you to leave us a question in the chat box. We can move on to the next slide here. Now, the Social Security Administration has multiple different programs that it administers that that people can apply for. There's two main ones that we're going to talk about, though. The first one is called SSDI, Social Security Disability Insurance. Sometimes you'll hear people use other names for it. Sometimes it's called Title II. That's where it's found in the Social Security Act, is Title II. Sometimes you'll hear it called DIB, Disability Insurance Benefits. The main disability program that we're going to talk about is called SSI, Supplemental Security Income. Sometimes that one's called Title 16 benefits, like Title II. That's where it's found in the Social Security Act, is in the Title 16. Now, just like I'm going to tell you about what the differences between those programs are, I want to make sure I tell you what the differences between those programs are not, because there's many misconceptions about what the difference is. Very often I will hear people say, well, Social Security Disability Insurance, that's the longer term one. SSD, that's for people who are going to be disabled for their whole life. Or, that's the physical one. SSD, that's the benefit for people who have physical, health challenges. SSI is for people that have mental health challenges. SSD, that's, the one that, automatically pays more money. There is no difference. That is not true at all. The difference between SSDI and SSI is not in the medical requirements. It's in the non-medical requirements. And let's talk about those. So like we just talked about on the prior slide, the difference between SSD and SSI, or the definition for SSD and SSI, is the same. So what somebody must prove in order to be eligible for those benefits is exactly the same. So how disabled you are, exactly the same. The difference is in the non-medical. So the big one is, in order to receive SSDI, you must have paid into Social Security, generally speaking, for 5 of the 10 years immediately prior to becoming disabled. 5 of the 10 years immediately prior to becoming disabled. What that breaks down to, and really the way that it's written in the law, is that means that you must have paid into Social Security for 20 quarters in the previous 40. The way that you earn 1 quarter of coverage is by earning about $1,200 or $1,300 per, in a year. Okay, so if somebody works and pays taxes pays Social Security taxes of about, let's say about $5,200 in a given year, then they should receive 4 quarters of coverage in that particular year, which should cover them, give them full SSD coverage for that year. You can't earn more than 4 quarters of coverage in a particular year. Okay, so that's very important. Now, and you see the star that's there in that work history box, because it would be very difficult for a younger individual to be covered for Social Security disability if they, with that, you have to have paid in for 5 of the previous 10 because of their young age and they wouldn't have had enough time. When somebody's under age 32, you don't have to have worked as much. Generally, you have to have worked half of the time between age 22 and however old you are, okay? Now let's flip to the other side of the slide here. With SSI, there is no requirement for work history. You never have to have worked or paid into Social Security at all to be eligible to receive SSI, okay? Instead, SSI is based on having limited income and resources available to you, okay? And this is something that's really interesting. And in fact, I was just on a conference call last week with Marcy Kaptur, who's the congresswoman here in Northeast Ohio. Actually, she covers all the way up to Toledo, so we'll call it, she's a congresswoman in Northern Ohio. And she was a sponsor of the Social Security Restoration Act, which is actually a bill that's attempting to bring up to date some of the SSI requirements, because, like it says, the SSI, instead of being based on work history, is based on limited income and resources. They have not updated what the maximum resources that an individual can have since the Nixon administration, okay? So since the late 60s, early 70s, they have not changed what the asset maximum is that somebody can have. In order to be eligible for SSI, an individual cannot have more than $2,000 in resources. Think about that. Think about how impoverished that means you must be in order to receive SSI. And think about what the difference between $2,000 in 1970 was versus what $2,000 today is, okay? And just to, dig even a little bit deeper, although, I guess we'll cover this a little bit later in the slide, but, there are some assets that don't get counted, but still will allow you to be eligible for SSI. Social Security does not look at the value of one house. They will not look at the value of a car if it's used for medical transportation, 2 cars if you're married. And actually the asset maximum goes up to $3,000 for a married couple, but still very low number, especially when you consider how long it's been since they have updated those numbers. Okay, so some other differences between the SSD and SSI programs. First, in the health insurance. SSD comes with Medicare, which is the health insurance that's provided by the federal government, but there's a waiting period. You don't become eligible to receive Medicare until you've been disabled for 24 months, but there's also a 5-month waiting period after you become disabled until that 24 months begins. So really, from the onset date of disability, you don't become eligible to receive Medicare until for 29 months, okay? With SSI, an SSI recipient becomes immediately eligible to receive Medicaid. So that's a nice feature. Now, the SSI immediate eligibility, it has changed in terms of the importance of it a little bit, especially in Ohio, because of expanded Medicaid, which we have, back in 2013, when expanded Medicaid was, signed into law by Governor Kasich at the time. That made it so, most people who would be eligible for SSI would, already were able to have received Medicaid. When I started practicing in 2010, there were a lot of people that were applying for SSI, not even because they wanted the money from it. That was one of the only ways that you could get Medicaid. So that was a huge motivating factor. And then lastly, there's some big differences in the monthly benefit, the amount of money that you receive if you're awarded SSDI versus if you're awarded SSI. So if you're awarded SSD, the amount of money that you're awarded each month, it's determined by essentially the amount of money that you paid into the system. It makes sense. It's based on your work history. That's how you become eligible to receive SSD. So the amount that you get out of it is based on how much you paid in. A good way to think of SSD benefits, it's like drawing your Social Security retirement benefits early, okay? So, you know, Social Security used to send those green printouts every year now that would, you know, essentially list how much money you'd be eligible to get if you're if you were to reach retirement age. It would also say how much money you would get if you were awarded disability. Those two amounts were usually about the same. Now that information is available right on Social Security's website. Another thing about Social Security disability is that you can actually receive back payments if you're awarded SSD benefits for up to 12 months before you've even applied. So a lot of times people will wait to apply for disability thinking that they're going to get better, or they just don't know about the program. And with SSD benefits, you can actually be, you know, back paid up to 12 months before you've even turned in the application for disability. So that's a nice thing for a lot of people. With SSI, the monthly amount, the payment amount is fixed by statute. This year, it's $783. That's the most amount of money that somebody can get, but there are some offsets. For every two, you know, there are some people who are working while they're receiving benefits. So for every $2 that they earn at work, there's $1 that's deducted from their SSI payment amount. That doesn't occur with Social Security disability insurance. And there's also offsets for food and shelter. So a lot of times I'm sure people have seen where they've had clients or people that they're working with that'll come to them and say, hey, Social Security is taking away a third of my money because they're saying I'm living with my family member and I'm getting food from my family member. That's a very typical offset, okay? So very often we'll see people that are only getting about, you know, $512, $513 a month because Social Security says, well, you don't need the full payment amount. You're getting free rent and free food from a family member. And then as opposed to SSD, where that back pay can go a year before you applied, with SSI, the back pay actually doesn't begin until a month after you file. So, and just so everybody knows what back pay is, because I'm using that word and I'm not explaining it. I'm getting a smile from Jen, so I know that
I have a question for you on that.
Probably was going to ask me, hey,
Yeah.
What is back pay, Michael? Back pay is when somebody is awarded disability benefits, because it takes a while to get approved. You know, and very often, because this is a system of denials and appeals, okay? So very often it'll take people 2 years to actually receive disability benefits. But when you're awarded Social Security, they will back pay you. They will give you the money that they should have been paying you for the period of time that you were waiting. And so when I use that phrase back pay, it's the money that they should have been paying you from either the period of time of your application until you were approved in the case of SSI. And in the case of SSD benefits, you can actually, if you prove you were disabled then as well, get paid up to a year before you even applied. So that's what back pay is.
I think too, an important thing, and I don't know if I missed this when I was logging back in, but did you talk about concurrent claims at all?
No, I didn't.
Oh, okay, perfect. I think that, can you touch on, you know, like there are these two programs, but there is this notion of a lot of our clients will actually apply concurrently, meaning they'll have an SSDI and an SSI claim together. And I think it's interesting to talk about those two together. That is possible, number one. And number two, you know, just a little bit about how that works and how you would, because I think that's one of the confusing things is when clients go to apply, they actually aren't aware of the two programs, or they are, or they don't know which ones they're eligible for, or if they're eligible for both.
Yeah, thank you. And I'm glad that you asked that. In a particular situation where that comes up a lot and it's important is, say, for example, somebody applies for disability right after they stopped working. You heard me talk about that 5-month waiting period, which is important in Social Security disability SSDI cases. Meanwhile, SSI doesn't have any waiting period until you can enter a pay status. You're eligible to receive an SSI check the month after you apply. So with concurrent cases, it's important that you apply for both benefits because you might be eligible to receive SSI benefits while you're in that 5-month waiting period for SSDI benefits to kick in. That's one situation where concurrent benefits are important, and it's good to have both applications pending. Another situation that we see quite a bit is where, say, somebody maybe had a spottier work history. So they were paying into Social Security, but maybe they weren't paying in a whole lot. Maybe they were missing a few years of work, or maybe they were even paying in consistently, but they had consistently lower earnings. So the monthly payment amount for SSDI benefits is lower, and which results in them receiving an SSDI payment amount of $400 per month. Supplemental security income, keyword being supplement, will kick them back up to what's called the federal benefit rate, FBR, where they can get the difference between, what their SSDI payment amount is and that federal benefit rate of the $783. So that actually, because they are receiving both SSD and SSI, they're still at least receiving that minimum, the SSI amount. So having applied for both benefits is really important to people in those situations. Those are the two most common, situations where concurrent applications are important.
I think too, and I just want to touch a little bit more on what you said about back pay, because a lot of clients are driven by the notion of back pay, and obviously, I mean, it can come in a large sum of money. It's very important that they receive the money that's owed to them, but in all of this, it has to be linked to their disability in the terms of when they became disabled. So judges are really looking at, did you touch on this at all, or? Okay, so judges are looking at medical records and trying to determine, well, what date was the disability or the severe impairments actually documented? So someone could say, oh, I became disabled on January 1st of 2017, but if their medical records aren't really in alignment with that, and I think we'll go a little bit more into this later on in the presentation, then that notion of back pay really can't come into play. So it has to align simultaneously with the date that they became disabled as documented in medical evidence.
Yeah, definitely. Why don't we move on to the next slide? And it seems like your webcam is working great at a perfect time.
I know.
You are now, girl.
Yeah, perfect.
This is Jen's world. Why don't you tell us about SSI child cases?
Yeah, so I think that, as Michael discussed with the adult cases, the level of scrutiny, I guess, or the things that judges are looking at for adult cases are, whether or not an adult can work. And children's cases are obviously different because we're not looking at that vocational question. We're looking at a functional question. And so there are child listings, and those are, requirements in the law that state, okay, if a child has autism, if they have, some other impairment, these are the things that need to be medically documented in order to meet a listing. But sometimes, and most of the time, those are not very clearly met, especially the cases that we get that will go all the way to the hearing level. And so then the question turns to this notion of functioning. And so it's called functional equivalence. And judges and Social Security evaluate this based on the 6 factors that are listed on this slide. What I have found in doing these cases are that it is extremely subjective. And it's extremely, you're at the mercy really of the judge, you're at the mercy of how credible the parent is. Obviously, in government systems, there are instances of people that abuse the system, and I think judges are really keen to that and trying to look for, a parent who's just looking for money but might not necessarily need it. I get a lot of calls about my child has ADHD and they're a behavioral problem, but that is not going to compel a judge to award benefits unless there is just really severe instances of behavior that's documented by the school, that's documented by a counselor that they see, that's documented by, a doctor, a pediatrician, a psychiatrist. That's where the ADHD becomes compelling. And I've done a lot of cases where those things are not in the file, and judges are like, well, what are, asking the parents, during the hearing, well, what are your discipline methods? And the parents really aren't able to express how they're disciplining their child. And that would lead a judge to believe, well, maybe the parenting needs to be improved, XYZ. So I don't know, I'm just sharing that because I think that it's really important to understand that there are listed functional, requirements here, but those are extremely subjective based on kind of the judge's view of what those might mean. But I do think it's important to bring up each of these and talk about each of them and what it might look like, so that when you're discussing this with a parent, you can be informed about how, like, okay, is there a case here, is there not? And what kinds of things that, if those instances are occurring, what would need to be documented in writing to help make the file more compelling for a judge or for Social Security to award the case. Do you have anything else to add to that, Michael? Because I know that you've done children's cases as well. I mean, what would you say has been your experience in terms of that subjectivity?
My experience with child cases, I think that you use the word that I'm always afraid to use, but I think, if we're gonna call it what it really is, there's just so much, unfortunately, subjectivity.
Yeah, it's true.
And especially with children's cases, I think that it comes down to the preferences or politics of the adjudicator, which is not fair. But when you look at how Social Security decides children's cases, and we've got this list here of these categories are called domains, and these are the things that Social Security looks at when they're rating how severely disabled a child is. But then when you break it down and you think about, how they rate the children within these categories, you can kind of see how there's not an exact point system. There's not an exact rating system. It's literally left up to the reviewer to decide. The language that's used is, so within these categories, they rate the child on their deficits in acquiring and using information. You want to give us some examples of acquiring and using information? That would be like in school, how well they are able to learn and learn to read and write and do math, right?
I think that what's important, and what I do appreciate about Social Security, is that they have written down examples of what each of these mean and what they're looking for. And a lot of them are broken down by age range. So, and pretty specific. I mean, from 0 to 2, 2 to 5, 5 to 8. So you're looking for, can an 8-year-old tie their shoes? And that's going to be more about, moving about, manipulating objects, caring for yourself, health and physical well-being. So if you take kind of a common sense approach to looking at these, and then you think about what would a, quote, traditional child be able to do in each of these categories, and then where is the deficit for the specific child that you're working with? And again, when I found as a teacher, and I, for those of you that work with kids, you may have had this experience, but not everyone comes into kindergarten knowing how to read. And then it's like by the end of kindergarten, they kind of all, are able to do something in that range. And then, there's kind of a lot of variation in each classroom from kindergarten, first, second, but then again in second grade, there's kind of more a closer, where kids are able to do kind of similar things at 8, 9 years old. And so what we're looking for is really a deviation from that. And are there significant speech delays? Were there significant issues with being able to, one indicator is before kids start reading, they can recognize, symbols like a McDonald's sign, and they know that that's McDonald's without knowing how to read the word McDonald's. So, acquiring and using information would be, how do you get this information? How are you processing it through your brain? And then how are you, able to apply that? Go ahead, Michael, did you want to say?
So now when we talk, so Social Security will give us a list of the activities that they're going to consider.
Yes.
But then when we go back to this concept of, okay, so then what's so subjective about it? They don't tell us what it means to, so here's the rating system that they use. A child either has no limitation,
Yeah.
they have a less than marked limitation, they have a marked limitation, or they have an extreme limitation.
Mm-hmm.
In order for a child to be found disabled, they have to have at least 2 marked limitations of these in this list of 6 domains, or they have to have 1 extreme limitation.
Mm-hmm.
But nowhere do they say what it means to have a marked limitation or an extreme limitation, or give examples of what that means. That is totally left up to the reviewer. Mm-hmm. And that's what to me is really problematic, because I've seen a judge say that one child has with this test score has a less than marked restriction, and another judge with an identical test score, maybe even a better test score, has a marked restriction.
Mm-hmm.
And there is no control on that. It is just, as long as they explain why they think that makes sense, Social Security says, good enough. You explained it, and the law allows that.
Yes, and so that's where you feel like when you get so personal and you're working with these clients and this child needs help, and more importantly, well, not even more importantly, but simultaneously the parent needs help helping this child develop and become, a really contributing member of society. And so I think what is important to share here today is, how do we help you guys help your clients? And so what are the kinds of things that will tip you over to a marked or an extreme? And it all comes down to documentation. And it comes down to documentation from specialists. I mean, these judges, if they can see that a psychiatrist has been with a client for 2 or 3 years and evaluating them on a regular basis, or just seeing them on a regular basis, then I think that becomes a little bit more credible. If there is a teacher who, and I mean, we're experiencing a lot of weird times with kids being out of school because we don't have that documentation from schools. And I'm constantly talking to Michael about how do we help our kids during this. But I think that's where people who are working with children and working with parents of children who are disabled can really help by documenting even more specifically the issues that the parent is having with the child at home. And so right now, any clients that I have that are helping with virtual school, even a hybrid model, I'm just having them keep a daily log of what is going on. Are they completing their assignments on time? We're going to see how Social Security starts to evaluate that, if they find that to be credible. I don't know. That's still kind of yet to be determined. I'm still getting questions from judges, well, pre-COVID, how did this go? But I mean, we're getting 6 months removed from that, and a child can be different in those 6 months. So I don't know. We'll see how that plays out. But I think what's so important is just the documentation related to each of these categories. And the more, the better. IEPs, the different evaluations at schools. I know that Ohio is very lucky. A lot of their public schools have great connections with counselors who come to the school, so parents don't have to, bear the burden of driving their kids to these appointments. But sometimes that documentation is a little bit sparse because people are in a hurry, people are moving on to the next client. But that is really what tips the edge and helps attorneys prevail in these cases for these kids. So trying to think of what else. Oh, go ahead, Michael.
You and I have spoken, and I'm trying to think if you said this just in other words, but one thing that I always want to make sure that I'm getting the parents of my clients to talk about in a hearing is the gap in services that they're experiencing.
Yeah.
And if I want them to say, you know what, right now, I'm doing the best that I can for my child. I'm getting them, they're getting the counseling that Medicaid is paying for. They're seeing the, psychiatrist at the community clinic that Medicaid is paying for. But what I'm being told is that there's this outside program. Maybe it's something like, and I will tell you, as the parent, this is me speaking myself, as the parent of a child who, as a toddler had special needs. And we were putting my daughter in like Taekwondo, and because everybody was telling us that that was something that would teach her a lot of like the motor skills that would really help her develop. You know what? If I'm a judge and I had a parent say, listen, I'm doing everything that I can, but I'm being told that these extra things that are out there, if I could just access those, that could really like help get my child to the next level. And I will do whatever I have to do to help my child. Those are the little things that really make a difference in a case, I believe. Now, Jen, you gave an example to me the other day of like a parent that told you, well, I want to take my child to like the arcade. That's probably not going to be helpful.
Part of my vetting process and talking to parents is, so, if you were to be,
and it was like gas to get to the arcade too.
Yeah, like given this additional assistance, how would you use the money? Because I think that is something that the judges are interested in as well. Yeah. And, the first thing was, well, I just need to put gas in the car. And I said, well, for what purpose? And I think that if it was, to get to doctor's appointments, to get to different things, then okay, yes. But it was about taking, the child to some extracurricular activities, which again is not bad, but there is a fine line of how that it can be viewed by Social Security. I think everyone wants to give their children the best opportunities that we can, but this program is narrow in terms of what it's supposed to be supporting. I think some compelling, things adding on to what you were saying, Michael, are, I've had parents change jobs because the job that they had would not allow for them to leave their work, go and deal with a behavioral issue at school, or take their child to the doctor. And they felt like if they actually worked at the school or did a more school schedule friendly job, then they were able to help their child more. And a judge really, that specific judge heard that and said, okay, I know that you're doing everything that you can to help. And so, I think it is subjective, but I think there are little things and are little ways to coach parents in terms of here are some small things that I think will go a long way. Research the extra things that you would do to help and to give your child the best opportunity to move forward. So it is subjective, but I do think that there are little things that can help to make a case more successful, even within kind of that frustrating constraint.
Yeah. I want to try and be respectful of it. I feel like we could talk for 6 hours. So why don't we try and move on to the next slide?
Oh, perfect.
Okay. And I think that we've maybe covered a lot of these things in the course of the presentation, but this is something that this is the gold in our presentation. This is what I really want to make sure that we impress upon you guys, that I want you to remember and pass on to others. When people come to us and they say, well, what does it take to win one of these cases? Mm-hmm. This is what I'm telling my clients, okay? So the first thing we have here is I really believe that one key to a winning disability case is a positive patient-provider relationship. And let me explain what that means. In every single new client meeting that I do, I tell my client that you're not going to win your disability case by filling out the paperwork that Social Security sends you a certain way. You can't talk your way into benefits. Mm-hmm. You can certainly talk your way out of them, but you can't talk your way into them. If you put on on a function report or a disability report that, in your free time, you're riding your motorcycle and going, jumping out of airplanes, and I'm being facetious, yeah, they might pick onto that and use that against you as part of their rationale for denying your claim, okay? But really what they're doing is using the paperwork that your clients are filling out to poke holes in the claim. They're not using that because oh, well, the person said that they're in severe pain and can only stand for 10 minutes. No, they're using the paperwork that your clients are filling out to deny the claim, okay? They're using the medical records that are being generated to approve the claim if they're going to approve a case, okay? So the key to a successful disability case, I believe, is to have successful communication with your medical providers. What that means is, make sure, if I were to be talking to one of my clients, I would want to make sure that at every single appointment that they have with a medical provider, they are telling them repeatedly, like a broken record, about all of their symptoms and functional limitations that are impacting their daily functioning. Now, this should not just be for the purpose of getting disability benefits. What I always tell my clients is, you get better and healthier the same way that you get approved for disability. What that means is, how can a doctor help you, or how can a therapist or counselor help you if you are not reporting to them what your daily life is like? If you're not showing up and telling them, yeah, my medications aren't working. I only left bed 4 days last week. There were 3 days when I literally laid in bed with my sheets pulled over my head, and I had to have other people bring food to me on those days. If you're not reporting things like that to your providers, they can't help you. They don't know to change your medications. They don't know to change the type of counseling they're doing. They're playing pin the tail on the donkey as your providers. So the way that you get better, which everybody should be motivated to do, is the same way that you get approved for disability, because hopefully the providers are documenting all of the things that the patient is or the client is coming and reporting. But a lot of that also then requires, so I guess I'm covering two things at once here. Great, I'm covering the next bullet point as well. What that requires is really having that positive relationship. You must find providers that you're comfortable communicating with, and not be worried about, well, I don't want to switch because will Social Security worry that I'm doctor shopping? Well, if you are seeing a doctor that you hate, so you just go there and you don't tell them how you're feeling, or you just say yes or no and you don't actually describe what's going on in your day-to-day routine, you're not going to get better. You're not going to be telling them your symptoms, so nothing is being written down. You're just totally, for all purposes, shooting yourself in the foot. I guess I covered a couple things there. Would you add to that, Jen?
Yeah, like one practical tip that I tell my clients is that if they have a smartphone or a way to kind of keep track of little things that they might forget because they have fatigue or memory issues or something like that, then I will have them keep notes just in their smartphone. A lot of my clients will keep like notebooks or calendars or daily logs. If it's a migraine client, like there's a calendar that you can just write down the days that you have the migraine, how long it lasted, how long did it take you to recover. And I think being able to, doctors are in and out so fast. And I think that, sometimes when they go to the doctor, they feel like, okay, they forget or get frazzled or like, they're not feeling well or whatever. So any type of little thing that will help my clients remember to be specific and communicate these things, because then those specific items in medical records just help judges see the limitations for being able to work even more clearly, which is the goal. That's where we're trying to go. But I think a lot of our clients need help and reminders and just little tips that can make their life easier to communicate, better, more productively.
Do you want to tell us about conscientious form filling?
Sure. I think you touched on that. I think what you were saying about the way that what you can say will hurt you. I think one of the examples that I've heard you give that I really appreciate is a work history report, which is required in all of the adult cases. So what have you done in the past? And Social Security will be using that in their evaluation. But I think sometimes people are very proud of the work that they've done, and rightfully so. I think that that's wonderful. But I think that Social Security is looking for any way to deny people. And so if you were titled in a certain job as a supervisor, but you didn't necessarily supervise anyone, then you don't want to be held to that level of work, because that's only harder, makes it more difficult for you to get approved. So I think being able to describe things just as they are in more plain and simple terms. One thing that I like to say is, if you're in a hearing and I'm prepping my clients, is it's better to be a little bit more, like, always answer honestly, but be a little bit more vague and ask Social Security, make the judge ask more specific questions. And that will give you an idea of where, they're going. But I think it's the same thing with form filling, is giving enough information, obviously, but the more that you put in can hurt you.
Just to kind of add on to that, because I think and you and I have talked about this so many times, and I think
Right.
it falls in the same thing, under the same thing, and it's not its own prong on here, but people need to leave their ego out of these cases. Yeah. And there's been so many times where the way that forms get completed, or the way that people will testify before a judge, it's like they have an ego about the work that they did, where they want to stand and I get it. I'm very proud about my professional accomplishments. Jen is very proud about her profession. We all should be. But your disability hearing is not the time to do it, because this is the time to humble yourself and answer questions as honestly and to the point as possible, because the more skills that you say that you have, the easier it is for a judge to deny you. And a lot of times people are talking their ways into skills that they don't even really have, like talking about work that they did 15 years ago that there's no way that they could do it now because of how much technology has changed, but they want to make sure that the judge knows about something that they did back then, because that's just an ego boost for them. But that judge is just going to use that to deny them. So
Right.
put your pride aside in the disability hearing.
Yeah, and when you really are disabled and struggling with something, and that is not something that you could do, I mean, that's when it's important to communicate the limitation. I like to tell my clients, everything that we're giving in terms of form filling, in terms of information, everything that we're giving to the Social Security Administration needs to have a lens over it that allows you to express your daily life and what that looks like. Because I've had this happen to me in hearings where, somebody will say, I can't walk for more than 10 minutes at a time. I can't, stand very long, and a couple of minutes later, they're talking about how they walk their dog every day. And you and I and everyone on this webinar has a picture in their mind of what a dog walk looks like. And it can be totally different. It could be a big dog. It could be a small dog. It could be, I walk my dog literally out 10 feet to go to the restroom or back, or you can walk a block. But it's the lens with which we communicate that allows the judge to kind of peer into their lives and, well, what does a dog walk look like for you? And so I think that, really communicating efficiently, that is something that you guys can help your clients do, is kind of tease out what does that look like in their life, and what would a judge grab onto, either rightfully or wrongfully, that could help or hurt the case. Because it's a form of communication. It's specific to the agency.
Yeah. Adhering to deadlines, very important. I am going to very quickly, because this isn't its own slide in here, and it really should be. No, let's go back, please. Sorry. Can we go backwards? Talk about the flow of a typical Social Security case so people understand deadlines. Most people get denied when they apply first for Social Security, okay? the most recent statistics released by Social Security show that about 70% of applicants get denied when they apply. That's why Jen and I have jobs. If the people who applied for disability, the people who were supposed to be approved, got approved, I would be a transactional attorney or a workers' compensation attorney or a personal injury attorney. The reason that we have practices doing these cases all day, every day, and nothing but this is because there are people that qualify for these benefits that are being turned down. This is a system, like I said at the beginning, of denials and appeals. Okay, Social Security operates this program no different than any other insurance company. It's like Progressive or Geico or any the insurance companies you see on TV. It's about maximizing what's coming in and minimizing what's going out. But there's a lot more money going out than there is coming in. So the way they try and reverse that, this has been in the news a lot the last month. If you've been paying attention to what they're doing with potentially delaying or getting rid of payroll taxes, which could change the Social Security and the Social Security Trust in particular. So this is going to be a real hot topic to watch. But most people get denied when they apply at first for Social Security disability. That does not mean they're not disabled. It means that they need to file an appeal. The first appeal is called a request for reconsideration in Ohio. The reconsideration appeal, it must be filed within 60 days of that denial. You have 60 days to file it. The reconsideration goes back down to Columbus, to Opportunities for Ohioans with Disabilities, which contracts with the federal government, Social Security, to review the claim again and decide if they can come to a different decision. Most people get denied a second time. So then they need to file another appeal, which is called a request for a hearing. A hearing is where you go before an administrative law judge and make your case to a judge for why you believe you meet the requirements for disability. Judges, attorneys, that's where attorneys generally come into play. But I will say that's shifted a lot. When I started doing this work 10 years ago, there was this conception that, oh, you don't need to hire an attorney until you've been denied twice. Today, most people hire me before they've even applied. And that makes a lot of sense to me, a lot more sense than waiting until you've been denied twice. And the reason is because the paperwork that we talked about that Social Security uses to deny people doesn't get sent after the second denial. It gets sent within a week of the application. So if somebody is waiting until they've been denied twice to hire an attorney, I can't protect them. But I also don't let my clients speak to Social Security. So if you've hired me before you've applied, then I can make sure that all of the paperwork in the claim has been filled out right. But anyways, at the reconsideration stage, the approval rates are about 9%. I think last year was only about 7% in Ohio. At the hearing stage, and I know this number is going to sound low, but there's also a lot of claims that just fizzle out at different points, that this is the period where people have their best chance of being approved. There's about a 40-45% approval rate, okay? If you take out dismissals, because a lot of claims just don't go forward, where people, they didn't file their appeal on time, or there's all kinds of things that happen, about half of the people get approved at a hearing, okay, nationally. And that's so that's what we're mostly building toward. There are appeals beyond the hearing level. You can file to the Appeals Council in Falls Church, Virginia. You can file into federal court all the way through the Supreme Court of the United States. I wanted to make sure I covered that, okay? But you must adhere to deadlines. At each of these stages, you have 60 days after a denial to file an appeal, because you can't be successful if you don't file the appeal.
Mm-hmm.
A lot of times people will say, oh, don't appeal, just refile. Don't do that. Don't do that. Refile. Because if you just start over, you're just beginning the process of being denied again. The key is get the case before a judge. Get the case before a judge.
And I do find, Michael, I think it's helpful that you went through that. I do find people that call me and they're so disheartened that they are denied that first round. And I try to if I've had them, you know, before they've applied, like just kind of set the expectation that that will probably happen. And please don't take it personally, but they tend to. So just be aware of that. If you are working with someone and they get that denial, it does not mean give up. If anything, it means, you know, okay, let's go now. Like it's even more. So the persistence is really important. But it can be exhausting and it can be disheartening because just the length of time that it takes to get through one of these is a little bit daunting, especially when you're not feeling well and you're struggling financially, or what, you can't work, you can't, you know, you don't have your normal life. Like it is a really hard situation for people to live in. And so I think that patience and understanding part is key. I mean, it seems simple, but it's really important.
We have written here the disability definition under Social Security. A lot of people will say, well, I should be approved for disability because I'm 100% VA rated, or, you know, workers' comp found me disabled.
Or I have a
Social
specific
Security has its,
diagnosis, or like
say it again?
if you have a specific diagnosis, like the doctor gave me this diagnosis, I'm disabled. Like those don't equate.
Right. Social Security has its own definition of disability. We told you at the top of the presentation what that was. Don't assume just because you necessarily meet a different standard for disability means you meet Social Security's standard for disability. The key is to remember what Social Security's standard is and tailor records to that and tailor communications with your providers to that. The last thing that we have on here, because I already talked about all those appeals and denials that you can be expected, have patience and understanding. An average case, and it's changed a lot. If you can believe this, you know, 10 years ago, a case from application to hearing with a judge, an average case would take about 3.5 to 4 years. Most of my clients, I shouldn't say most, but a good chunk of clients, by the time we got to their ALJ hearing, were homeless. Now we're getting to hearings from application in a year, 14, 15 months. Things are moving, you know, quick, but so it seems fast to me. But when you don't have an income, when you're struggling with food stamps and you know, Medicaid, you have to keep renewing it again and again and again, and that's creating stress on top of everything else that you're dealing with in your world. That's tough, but you have to be patient and understand that this is a process. So that's one thing that we always want to stress to people in managing expectations, because to be successful with a claim, you have to have that. Otherwise, you will drive yourself crazy.
Yeah, that's true.
So move on to this last slide here. Again, we want to be respectful of people's times. Hiring an attorney, because we get a lot of questions about that. I think I spoke a little bit about, you know, when people hire attorneys. I talked about how, you know, now I think that, you know, people tend to hire me before they've even applied because of, one, it's the same fee. People used to want to wait to hire an attorney until they'd been denied twice. I think a lot of people thought that, well, what happens if I then get approved for disability right when I apply? Then I don't have to pay an attorney if I didn't hire them right away. First of all, attorneys are not making their money off of initial client approvals. Here's the truth. I lose money because of how much time we put into a case at the beginning of it when a client gets approved at the beginning. That's okay with me. I operate an entirely word of mouth business. Many of you may not know who I am unless you've been told about me by other people in the medical community. That's because you will never see my face on television, on radio. I only get business by word of mouth. That's intentional. I only get business by doing good work for people. And you cannot survive, you know, growing a business the way I've grown mine if you are intentionally losing cases to try and get a bigger profit. You have to work hard and really care about your clients to succeed in business the way that I've grown my practice. But I think that this is an important one, though, to talk about, who an ideal client is, and I think that the prior slides covered a little bit. Somebody who's treating, seeing specialists. You mentioned that, Jen, right?
Yeah, I think for me, it's, and kind of going back to what you said is when people will call and they say, I'm still thinking about applying for disability, we'll go through communicating with them. And you can give them a leg up when they haven't even started applying yet. There are people, and I know you do this in your practice too, that I just don't think you're ready yet to apply. And I don't want you to be unsuccessful on that first attempt. So let's, follow these things for the next couple of months and then call me back. But I think that, for an ideal client, and, I think what we mean by that is, obviously these are people who are who need support and help, and they're at a very hard time in their life. I mean, traditionally, I have clients who that's not the case, but they're not feeling well and they can be struggling financially. And so I think for me, someone who just is, will listen and kind of take my advice and be treating and go to the doctor's appointments. Everyone was up in arms about what do I do during COVID. If you can make a telehealth appointment work, a phone call appointment work, please continue to do so. Those records are still going to matter during that gap period. The judges are going to be understanding, but to the extent that you're just showing that you're an active part of getting better, that you really are doing everything that you can to get better and to get yourself back to health, judges appreciate that. Social Security is looking for that. And so I think that when people are really working hard to get themselves better, it's going to show in their medical records. What kinds of treatment have you had? For a physical problem, or physical therapy? Are you trying different medications? Are you listening to your doctor? If you have diabetes, are you eating right? Are you doing things that support your health? Those are the things that we really want and encourage our clients to do. I think, like Michael said, the contingency fee, there's a lot of misinformation about this, which is so interesting to me. But my clients will say, I hesitated calling an attorney because I didn't think I could afford one. And, we are only getting paid on these cases when we win the claim. And so, those first meetings, all that information that happens, prior to that win is of no charge to our client. And so we are able to help people who, in a traditional sense might not be able to afford an attorney, which is, a very, very rewarding thing, I know for both of us. The information ready and at hand. I just struggled with this actually during a case this week where my client could not tell me who his doctors were and couldn't tell me their names, where they were treating. I always say, grab a business card, take a picture of it with your phone, anything that you can do to help us get that medical information. Social Security is going to need it. We want to cross-check what Social Security has with what they've requested. So we're always making sure, tell your client if they treat, have that information somewhere accessible, somewhere ready, so that, that makes their job and our job a lot easier to do. And you would be surprised about how that trips people up so much. It's a little bit frustrating, but if they know from the outset that they have to have that information ready, most of my clients will work hard to get that organized and keep that readily available. Do you want to talk about medical support?
Yeah, and I think I said this when I said, the importance of treating with specialists, but I tell my clients that for every impairment that you think is severe and preventing you from being able to work, you really should be seeing a separate physician for that. Now, maybe let me take a step back. You should be seeing a specialist for that. Okay. If you have migraine headaches and seizures, you're going to be seeing a neurologist for both. Maybe you're seeing a migraine specialist and an epileptiform neurologist separately, but there are neurologists that can very competently treat both. However, what I do caution people is I have people call my office daily looking for me to represent them who say, I have 12 medical issues and I'm only seeing a primary care physician. I probably can't help you. And the reason is because PCP notes are so insufficient 99.9% of the time that there's just no way to make a case using them. Think about a primary care physician. Most of the time, if you're somebody who's totally disabled and you're applying for benefits because of, these health conditions, the doctor comes in the room, and you want him to treat this whole list of conditions. There's not enough time to address those things. But then he leaves the room and he walks in and he treats somebody's common cold. It doesn't make sense. You really need to be seeing specialists for these problems if you believe that they're so significant that they would keep you from being able to work. That's what judges are expecting. Otherwise, you're just teeing them up to say, even though there was a diagnosis here, the treatment was so conservative or non-existent, maybe you're getting a medication for it, but you know what the purpose of a medication is? It's to restore functioning. So, that it wasn't enough to support the severity that was alleged. You really should be seeing a specialist for the issues that you consider to be severe and somebody that you can be transparent with. We talked about that before.
What do you think about this? I have a lot of clients who, because they're in the place that they're in, they are experiencing more mental health issues. Like say they haven't had experience with that in the past, or it's been limited. That's not their primary impairment. One question I'm always asking is, are you seeing someone for your mental health? I think a lot of my clients will have undiagnosed depression or anxiety or things that, they could benefit from talking to a counselor about, and they just are not because of the ego factor or because of various things that they can't. And I don't want to ever encourage somebody to go seek treatment if they don't need it. That's not the road that I'm ever trying to go down. But I think if there's a gap there, and it looks like someone just really is struggling and needs support like that, that is something I'm encouraging. If they have a physical ailment, a physical issue, and it's prevented them from working, and they're sitting at home where they used to be at work 40 hours a week or more, where that is depressing. That would depress me. And so I do think that I see clients struggle with that, even though they haven't had a history of mental health issues. And that's something that I think can be helpful, just to show the type of person that is and the type of things that they're struggling with when they can't provide for their family, just dealing with all kinds of external factors that wouldn't be covered in a physical health exam. It might, but it would be more specific to, a therapist, a counselor, a mental health professional. I don't know. Do you agree on that?
Yeah, I absolutely agree. I absolutely agree.
Go ahead.
And I think that I would just close by saying, and Jen and I see this both. I mean, sometimes the clients who are the hardest to help are the ones that we both think need it most. And that goes back to that ego factor that we talked about on the prior slide. I can't tell you how many, clients I've worked with who are people that just put on a hard hat every day for 40 years and refuse to ever see a doctor. And their health issues will even get so significant that they can't work anymore. But you also can't get them to go to a doctor. And when they go to a doctor, they just refuse to tell them what's wrong. And a lot of times I'll have to tell them to either take their husband or wife or their spouse, whatever it is, with them to the appointment. Can you please go to the doctor with, Mr. or Mrs. whoever, and tell them what you're seeing at home? Because I know that the medical notes, aren't going to be supportive if you don't. So, it is just so important that, and this goes back to the beginning here, somebody who's ready to be transparent with doctors. Because again, if somebody is going to the doctor, but they're not telling them what's wrong, they're not reporting those symptoms, they're really just at such a disadvantage. So those are the cases that I like, because truthfully, I think a lot of judges get it. There was a case that, Jen was like looking at recently, was like, there's just not much here medically. And I'm like, you know what? your best evidence here isn't going to be the medical evidence. It's going to be the work history. Your work history is going to win this case, not what the medical say. Because I just hope that this judge sees how long and how hard that person worked for, and that's what you're going to have to lead with.
Yeah.
And I get those cases all the time too. But I want to thank everybody. We can go to the next slide, for giving us a part of their afternoon. Unfortunately, we didn't get to see exactly who our audience was today. But again, if you guys have questions, please feel free to reach out to us. I'd love to know who you guys were. If you just want to send us an email and say hello. I am always happy to present to your organization something that's more tailored to you. We had to be kind of broad and generic today because I knew we were presenting to such a gap of professionals, but we would be happy to come in and talk to, because I know that the people that are on here probably are a big cross section. So if there's something more specific that we can do that would be beneficial, we would love to come and speak to your agency. So just let us know how we can be of assistance, whether it relates to a particular client or it's a training that we can do that would be beneficial for you. We're here, we're in the community. Even though Jen's, not physically in Ohio, she is working with people in Ohio every day. So she's here even if she's not here, and COVID has only made that even easier for her somehow. But we really appreciate it.
Yeah. And I think we all have the same heart to help people, and I think that's where Michael and I know Shannon, we just want to help people that need it so badly. So even any question, no matter how small, we would love to just kind of talk you through it and give you more information or help if you need it. So thank you.
Thank you guys so much. That was a lot of great information, and much better than trying to just read through some stuff on the internet and figure it out. I'm telling you. Thank you guys so much.
Thank you, Shannon.
All right. You guys have a good night, day, weekend.
Thanks. Yeah, you
too. Month.
Yeah.
All right. Thanks, everybody.
Thanks. Bye-bye.